57.
Good afternoon, everybody. We'll go ahead and get started. Thank you for joining us on this rainy day. For our speaker today, we have Patrick Bush, who is a staff attorney with the Legal Counsel Division here in the State Courts Judicial Branch, and he's going to be talking to us about things that you need to know when you're using the e-filing system. Please help me welcome Patrick.
Thank you, Liz, and thank you everybody for joining us at such short notice. I know we've got a lot of people who are also here electronically, and glad we have so many people with us for our CLE. The top 10 things you need to know when you use the e-filing system. We in the state court administration have been talking with court administration and judges from around the state. What is on the phone? What do people need to know? What do they need to do differently from the e-filing? We have about 2 years of mandatory e-filing. So that's what this presentation is based on. This is the first in about 10 sessions of this presentation we'll be offering around the state in the next, for the end of the year to talk about what lawyers need to do differently when they use the e-filing.
Some ethical issues for attorneys. The very first rule of the rules of professional conduct is the rule of competent representation, and the rule specifically talks about staying on top of changes to the law and changes to technology. There's also the ethical duty to supervise staff. A lot of the e-filing is done by administrative staff in practice. However, as attorneys, there is the obligation to ensure that your staff have the necessary knowledge of the law and that they are compliant with the law. And also, at any point, if you have any questions during the presentation, if you're electronically, please type them in and I'll be able to see them. If you're here in the room with me, please raise a hand, wave at me, and I'll be happy to have questions at any point. Talking about sanctions, there have been some specific examples of sanctions resulting from failure to follow the e-filing rules. This is a Minnesota Court of Appeals decision from 2016. It started as a discovery dispute in district court, and it was in a county where e-filing had been mandatory for some time. And one side served the other side with some interrogatories and requests for discovery, and the other side didn't respond. There was then a motion to compel discovery and a motion for attorney's fees. And the response was, well, look at the file, there's no affidavit of service, and since there's no affidavit of service for these discovery requests, I don't have to respond to them. But the response was, well, the e-filing rules say, and they've said for quite a while, that there's no affidavit of service required if you are e-serving. And in this case, you have the e-service records, and they say not only were the requests for discovery served, but you can see down to the minute the specific time that the attorney opened and viewed these interrogatories. And so the judge not only granted the motion to compel discovery, but also awarded $999 in attorney's fees. This was an appeal to the Minnesota Court of Appeals, which said, well, the rule has said that there's no need for an affidavit of service, and the records did show there was service, so the award of attorney's fees is upheld. There was a petition for further review to the Minnesota Supreme Court. Further review was denied. There was then a petition for a writ of certiorari to the U.S. Supreme Court, and that was also in a one-sentence letter denied. So just as an example of where things can go wrong, remember with e-filing, e-service, affidavits of service are not necessary when there has been service through the e-filing system. Now, this here is embarrassment to the attorney, $999 in attorney's fees, but it can get more serious. This is another Court of Appeals decision, also from 2016. It's a little bit grimmer, where the client's parental rights had been terminated, And under the relevant court rules, the appeal period is only 20 days for a termination of parental rights, and to effect the appeal, you have to serve the notice of appeal on both sides. And the attorney's assistant, instead of serving the notice of appeal, she sent it by email to the county social services agency, which had petitioned to terminate parental rights. And the county social services agency said, well, wait a minute, we did not consent to service by email, and there's not jurisdiction here because the appeal was not served on us within 20 days. The Court of Appeals agreed and dismissed the appeal for lack of jurisdiction. And because the notice was sent by email instead of e-service, not a valid means of service under the rules of appellate procedure, client lost the ability to appeal the termination of her parental rights. So it is just examples of where things can go wrong, of some of the serious consequences that can happen when people don't stay on top of the new e-filing rules. So the number one thing that we need to know is, that you need to know as a filer, is to read the rules. Both of the situations I just described could have been avoided if the attorneys had read the rules, had stayed on top of the rules regarding e-filing. The court rules have been amended several times since 2014 to allow for this transition to an electronic court system, and the number one thing is make sure that you're up to date on the rules. If you're looking at a printed rule book, they may not be up to date. You can find the most up-to-date rules on the Judicial Branch website at mncourts.gov/rules. Another option is, if you'd like to know when the rules are amended, there's a little that says click here to be alerted when the rules are amended. You can click on that, you'll get an email every time the rules are updated. So show of hands, how many of you can tell me off the top of your head what General Rule of Practice 11 does? Okay. See a couple of my colleagues raising their hands. A couple of, as lawyers, we think about Rule 11 sanctions. That's Civil Procedure Rule 11. Well, in Minnesota, there are two Rule 11s that we need to focus on. There's also General Rule of Practice 11. And what that rule says is it deals with restricted identifiers, things like social security numbers, employer identification numbers, and financial account numbers, things that can lead to identity theft. And the rule has said for several years that that type of information cannot go in a public court filing, and the filer is responsible for screening out those restricted identifiers. That's a common point of confusion that we see where filers think, oh, court staff will screen out for me, and the rule is very clear. It is the person filing it who is responsible for screening out that non-public information. The change in 2015 was to add a striking process. And that's what can happen is, remember, court staff don't screen your filings for you, but if court staff happen to see that there is a restricted identifier, with the change that went in 2015, they are directed to strike the filing. What that means is you get a notice from court staff, you have to redo your document, refile it, you lose your filing date, you have to pay the additional filing fees to refile your document, and there's also the potential that you can get additional sanctions by the judge. So that's one of the things when we say read the rules, one of the rules that was amended in 2015 with the transition to electronic filing, and the potential for some serious consequences for attorneys and their staff if it's not followed. Another rule that was amended in 2015 is General Rule of Practice 14. That was rewritten. That's the rule that governs e-filing, e-service. It was rewritten in 2015. It sets out a number of new requirements for everybody who e-files. That means attorneys, that means people who are self-represented in e-file, everyone who e-files. Another, just like to say show of hands, it's sort of a verbal tick of mine, but how many of you, show of hands, have read the Rules of Public Access to Records of the Judicial Branch? I'm happy to see the number. Usually that's the one where we see people aren't always paying attention to it, but just like the general rules of practice, the public access rules apply to all types of court actions. What the public access rules do is they dictate what information is public, what is non-public. If you go to other state government agencies, they work under a statute called the Minnesota Government Data Practices Act, and that's for them, for their records, that dictates what's public, non-public. Here in the state court system, it's the rules of public access to records of the judicial branch. That is one thing that filers we recommend that they pay attention to are the rules of public access. And all of these rules, with General Rule of Practice 11, General Rule 14, and with the public access rules, if there is noncompliance, there's always the potential for ethical issues. In general, there is the ethical duty to know and follow the rules, to stay on top of them as they're amended. And there's also that ethical responsibility for ensuring that administrative staff involved, paralegals, executive assistants who are involved with preparing court filings to make sure that they are also following the rules. And as attorneys, that responsibility can't be abdicated to staff. And with the electronic shift to an electronic court system, there are a lot more consequences, a lot more steps to the process of e-filing. And there have been times where use of the EFS system, it is audited and it is monitored. There have been times when the Office of Lawyers Professional Responsibility has asked to see EFS audit logs as part of an investigation into potential ethical violations by attorneys. So again, there is always a responsibility for attorneys to read the rules. Now, the number two thing that you need to know when you use the e-filing system is that public can be everywhere. That's the way we phrase it for the slide, just because that would fit into the title bar. But what you should do, the way we put it is, you should assume the world will see everything you file with the court. The public access rules, if you read them, they do say that all court records are presumed to be public unless there's a specific legal reason for making them non-public. And yes, that does include all the detailed personal information that gets filed in court cases. We'll see it often in especially family court cases, or maybe there's a custody dispute. Maybe there's social media postings or arguments in detail about who's the better person to take care of a child. Then all of that information is public when you file it into court. And again, basically, if you wouldn't post it on Facebook, think very carefully about whether, seriously, if you wouldn't post it on Facebook as a rule of thumb, think carefully about whether you should file it with court. In other contexts, there are confidentiality laws like Minnesota Government Data Practices Act with a lot of very detailed confidentiality provisions. If you're in the medical field, you have to think about HIPAA. If you work in the education field, there's FERPA. All of those laws, they don't apply when you come into court. It's the rules of public access that dictate whether information that's filed with the court is public or non-public. And you do need a legal basis to make filings confidential. I like to use real-world examples. Let's use the late, great artist Prince. Passed away in 2016. May or may not know that he went through a divorce in 2007 in Hennepin County, Minnesota. Now, due to the celebrity of one of the parties, they understandably asked to seal the divorce files. And what they did is they stipulated a proposed order and said, we, just by agreement, would like to have our divorce files, our negotiations be non-public. And initially that was granted by the court. They negotiate their divorce by relying on confidentiality. They were very detailed in their court filings. In 2016, Prince passes away. There's media interest in his life, and the Star Tribune files a petition for access to the divorce records. Now, the surviving ex-spouse objected very strongly to this, pointing out, quite reasonably, that there had been, they relied on confidentiality when they were negotiating the divorce, and there was a real risk that people were trolling the file just to, the curiosity, maybe they wanted to exploit some of the, non-public information that was in there. And they also said, well, not that long ago, President Trump was just elected, and then people said, well, he was divorced in 1990 in New York, and let's read his divorce file. And the New York State Court said, no, you don't get to read Donald Trump's divorce file. But Minnesota, we do have Minnesota laws. The presumption is that divorces are public, and so over the objection, the Prince's divorce case was made public. You can read it today if you want to go to any public access terminal. And one of the things the court said, and this is again district court, so non-precedential, but one of the things the court said was, Any confidentiality concerns are waived when described in documents filed in a court file, even if the file is at the time sealed. So just as an example, unless there's a legal basis, specific legal basis, you should assume that everything that gets filed in court is public. Public Access Rule 4 lists all of the non-public case records. And, if there's a need to depart from the public access rules, judges do have the authority to issue protective orders limiting access to otherwise public case records, and they can do that on a case-by-case basis. The public access rules also say they can't do standing orders, so maybe there's a judge in a county somewhere who says, I want to make all divorce cases confidential, that's my standing order. Under the access rules, legally, it does not have the effect of law. Only the Supreme Court can establish rules of access that affect multiple cases, but judges can issue orders in individual cases. But the judge must make findings that are required by law, court rule, or case law precedent. So, for example, if you're in a civil case, if there's a Court of Appeals case called the Schumacher case that governs access, there's a separate standard for criminal cases because there are some constitutional issues where there's a right of access to criminal cases. And it all depends on the case type and the document type that you file. But again, the assumption should always be it can be public and it can be viewed everywhere. Remember, this is an electronic court system. The expectation of the public and the reality is on-demand, near instantaneous access to court records. Now, the number 3 thing, and this ties in with number 2, is the obligation to separate non-public information from public information. Again, you, as the attorneys, you control what you file, and court staff are not responsible for screening your filings. As a law clerk, I know we have a number of law clerks on the webinar. If you are drafting a court order, you should make sure that it's very clear what the judge wants to make public and what the judge does not want to make public. Unlike attorneys, judges do in general have the ability to put non-public information in public court orders. That's part of their authority as judges. But you should always try to be clear with your judge what they expect to be public, what they don't, because court staff are not responsible. They don't have the authority to screen filings for non-public information, to alter information that has been filed incorrectly as public or non-public. For filers, the rules do say that they are responsible for separating non-public information from public filings. That's General Rule of Practice 1102 addresses restricted identifiers specifically, and Rule 1406 talks about anything that you e-file that you are responsible for designating it as public or non-public. And again, that's based on the Supreme Court's rules of public access, which identify what's public and non-public. Let's talk about a really important issue, restricted identifiers. Like, they're so important they get their own rule, General Rule 11. Restricted identifiers are defined as social security numbers, employer identification numbers, and financial account numbers. And the reason why this is so important is identity theft. These can be used to steal people's identity, and in fact, in several other states, public court records with social security numbers have been used to steal people's identities. We have rules in place to make sure that it doesn't happen here in Minnesota. Now remember, there are 3 types of restricted identifiers: social security numbers, employer identification numbers, and financial account numbers. Where we typically see issues with compliance are with financial account numbers. It's not just your social security number, not just a credit card number, but any financial account number is a restricted identifier. If you're wondering what a financial account number is, you can look at the end of your handout, the very last page. We have a summary sheet of what are considered financial account numbers. It's posted on the minnesotacourts.gov website, so it's there for reference for members of the public. Now, as I said, court staff are not responsible for screening your filings for restricted identifiers, but there is that striking process. If they do see a restricted identifier, then they are directed to initiate the striking process. So if you're wondering what are court staff directed to consider a financial account number, this is the same list that's available to court staff. If they see a number, remember they don't screen for them, but if they see them, they're directed to take action. That is the list of numbers that are considered financial account numbers that could lead to the striking process. You will look at the rule. If you look at the rule, you'll see it does say that you can list the last 4 digits of financial account numbers in public court records. The one exception to that is social security numbers. If their social security number is also the financial account number, no part of it can go in a public court record. The reason for that is that it is in fact possible to steal someone's identity using just the last 4 digits of a social security number. Since the first 5 numbers for most people were not randomly generated, you can predict the first 5 numbers. If you have the last 4, you can steal someone's identity. So social security numbers stay out of public court documents. That is the responsibility of the filer. Another change that went into effect, social security numbers, that's been in the rule since, I believe, 2005, but in 2015, the rule was amended to say only file social security numbers if they're germane and necessary to the issues before the court. A lot of the time, it's really not necessary to give the court restricted identifiers. If you do have to submit a restricted identifier, there are times where you have to do it, then you have Form 11-1. And if you have to submit a financial source document like a bank statement, a tax return, a W-2 form, that goes under a Form 11-2. The Form 11-2 is a public cover sheet. That's what lets people see what was filed in the court file. Now you can see we've said in block capital letters, Form 11-1 is only for restricted identifiers, and Form 11-2 is only for financial source documents. We say only because, I mean, sometimes people try to alter the forms to use them for other types of information. Form 11-1 is really only for those restricted identifiers, and Form 11-2 is only for financial source documents. If you work in juvenile protection cases, you'll know there's also a Form 11-3 and Form 11-4. That's a small category of cases. I won't get into it today. But the thing is, Form 11-1, 11-2 are only to be used as intended. Sometimes we'll see people use them to try and submit other types of non-public information like medical records, and those Forms 11-1 and 11-2 should not be used for that purpose. Let's talk about terminology. This is both, I think, for filers and for the law clerks. You've got the terms confidential and sealed. Sometimes we'll see people file an order or a motion saying these records shall be confidential and sealed and inaccessible to the public. Thing is, confidential and sealed mean 2 different things. They're both defined in General Rule of Practice 14. Confidential means that the document is accessible not to the public, but it is accessible to court staff. But if it's sealed, that means not only can the public not see it, but also most court staff can't see it either. Really only the judge can see it. So if you are an attorney filing a proposed order to make some records confidential, make sure you specify either they're confidential or they're sealed or they're inaccessible to the public. Don't say these records shall be confidential and sealed and inaccessible to the public. They mean 3 different things. If you're a law clerk working with the judge to draft an order sealing records or making them confidential or making them inaccessible to the public, just understand those words do mean different things. They are legally defined terms. As I mentioned earlier, every time you e-file, you have to designate your documents as public, confidential, or sealed when you file. And you can see up on the screen, this is a screenshot taken from EFS system. It's the filing comments field. And to make it abundantly clear to filers, we've added language to it saying, is document public, confidential, or sealed, ? And every time you file, the system will not allow you to file until you type something into that field. So the expectation is for whoever's filing this, the attorney, support staff, whoever, that they have to actually type in. It used to be, if you click radio buttons, public, confidential, or sealed, and it was changed to make sure that there's that reminder to people that that is your responsibility as the filer to designate as public, confidential, or sealed when you file. And again, remember, unless there's a specific rule authorizing you to file it as confidential, or if there is a court order authorizing you to file it as confidential, then the document is public. If it's something that's embarrassing to your client, something that your client would really rather that world not know about, you may want to think twice about whether that needs to be filed with the court. Again, separating public from non-public, that does mean that if you have public documents and non-public, they should be filed as separate documents, as separate PDFs. So maybe you've got an affidavit, it's, I don't know, a personal injury case, and you have an affidavit with a medical record attached to it, or it's a custody dispute and you have an affidavit with a custody evaluation attached to it. Generally, medical records and custody evaluations are non-public records, but the affidavit is public. So if you do file them, make sure that they're separated and filed as separate PDFs. That will allow court staff to process your documents more quickly, and it will ensure that the records are kept, that there's appropriate public access to the records. And for the law clerks in the audience, if you are drafting an order, sometimes your judge may want to have a confidential attachment to the order. Make sure that that's clear to court staff that there's the public part of the order and the confidential part of the order. Because they are directed to assume that everything the judge, unless it's specifically directed by the judge, they are directed to assume that it's public. And again, court staff, it's not their responsibility to screen filings for you for public access. Sometimes, in the paper world, it used to be you could just have all of your court filings and you had maybe a confidential part, you tag it as confidential, put it all in an envelope, mail it off to the court. But in the electronic world, you do need to have the public and confidential as separate PDFs. What you can do in the e-filing system is just file them in the same virtual envelope. That way it'll be clear to court staff the documents belong together. It'll be set up in the electronic records system so that you can submit your documents in the same envelope, and it'll be clear to everybody, including the judge, that the documents belong together. Another rule that went into effect with 2015 is that even though you have the obligation to separate non-public and public documents, you can quote directly in general from non-public documents in your public court filings, and the full details are in Access Rule 4, Subdivision 4. That does mean if you have a medical record, a psychological evaluation, you can quote from that in an affidavit if you'd like, or in a motion. The thing is, the other side also can quote from them. So again, that goes back to being careful about what you file with the court. And again, being a lawyer, I always have to focus on what could go wrong. Also, a little bit for shock value, I'll be honest. This is language directly from U.S. District Judge opinion from 2010. What happened was the attorney had filed some documents containing several people's social security numbers and some financial account numbers, and this was brought to the attorney's attention by the judge. Always a bad thing if the judge says, counsel, I need to bring something to your attention. At a hearing, the attorney says, Your Honor, that was a clerical error on my part, and I will have it fixed. And again, the attorney called it a clerical error to have it in the social security numbers in a public court record. All of this information made its way into the order sanctioning the attorney. And what the attorney then did is to file a version of the document where instead of redacting, they just drawn black rectangles in Adobe over the PDF, which I see some people laughing in the room. Everyone should know by now, if you just draw a black rectangle over an electronic document, that is not redacting it. It does not work. You have to actually electronically redact it. There's a whole tool for doing it. So then the judge sanctioned the attorney, and among other things, she wrote, the days of attorneys being able to ignore the computer and shift blame to support staff in the event of an error are gone. The consequences are simply too serious. It is the responsibility of counsel to ensure that personal identifiers are properly redacted. And not only on top of that, the attorney was ordered to, within 10 days, notify every affected individual in writing, offer to provide each of them a year's worth of free credit monitoring services at the attorney's expense, pay $300 to a local food shelf, and also appear before the court in person 2 weeks later to report on the status of the credit monitoring. As you can see, you have an unhappy judge, sanctions for the attorney. We hope that that case did not lead to anyone's identity being stolen, but that is just, it illustrates the importance of attorneys paying attention to the obligation to separate public from non-public, and also for every person involved with the filings to make sure that they are aware of that obligation. And this actually, if you go and you key cite this order in Westlaw, you'll find that a similar thing happened a couple of years later down in St. Louis, Missouri, in another federal court, and the judge there issued a similar sanction, except for a little bit more creative. The judge said that the attorney had to give every attorney and support staff and other person in his office who was involved with electronic filing a copy of the e-filing rules and instruct them to read the rules, and then specifically read the rules, and then not only that, but to file a written statement in the public court records saying that he had complied with the order. So just, sometimes there are judges who will sanction for violations of these rules. In terms of other things going wrong, there's always that potential for personal information in court filings embarrassing your clients. We in state court legal often hear from court staff that attorneys don't realize that, yes, most of this information is public and court staff are not screening for you. We in state court administration, we talk about a concept, practical obscurity. It used to be in a paper world. Yes, these records were public, but they weren't really public. If you had a case up in Coochin County, you had to drive all the way up to International Falls if you wanted to read the court records. I say Coochin County both because it's remote and because the name is kind of fun to say. But the thing is now with Coochin County, now that it's public electronic court records, you can just go downstairs to the public access terminals in the state court law library and read the Coochin County court records. For the law clerks, every one of your courthouses has at least one public access terminal where you can read any public case records filed anywhere in Minnesota since, I think it's 2013 that they started imaging case records. So, in an electronic world, on-demand access is the norm, and that is the same thing in the court system. It does require this a change in practices by attorneys to pay attention to the fact that, yes, your court records are public and you are responsible you control what you file, you're responsible for designating anything that's non-public. Number 4 in the top 10 things, document security classifications. To help ensure appropriate public access, to help ensure any legal restrictions on distribution of court records, we have a detailed system of electronic document security classifications. So the role in this as the filer is to make sure to designate every time you file documents as public, confidential, or sealed. And again, you need a legal basis to designate it as confidential or sealed. I will show you this. You can use the filing comments field. I showed you that screenshot earlier. You have to type in public, confidential, or sealed. You can also type in an explanation of why it's confidential or sealed. Is there a specific court order, a specific legal authority? So that's very clear to court staff that they know that the document security classification needs to be non-public. And again, for the law clerks in the audience, if you're drafting court orders, judges, the presumption will always be that your orders are public. If you put otherwise non-public information into a court order, the court staff are directed to assume it is public. And again, that's within your judge's discretion. It is simply, I say that so when you draft court orders, do keep public access in mind. So how many of you have seen a long register of actions in a case where it's just a long line of document other, document other, document other? I see 1, 2, 3, 4 people have raised hands. Thank you very much. Well, every time you file, this is number 5, you have to select a filing code. And again, that's a mandatory field in EFS for every document that you file. Well, when you have document other, affidavit other, it's very hard for you to read the case records. More importantly, it's hard for the judge to read the record to find the specific documents that you have filed. So what you should do, and this is to use the most precise filing code possible. In the screenshot we have up, you can see there are a bunch of different types of affidavits for filing codes. To recognize there are lots of affidavits. Let's say, for example, you've got an affidavit of service, then you can choose the affidavit of service code instead of affidavit other. Let's say you could be even more specific and select affidavit of service by posting if it's an affidavit that there was service by posting. By choosing those precise filing codes, you make it much easier for the judge to find the specific documents that you have filed. If there are a lot of filing codes, but what you can do a word search when you are in EFS. It'll select filing codes that have the specific words. So you can type in affidavit, you can see all the ones that have affidavit. By using these proper filing codes, it helps ensure appropriate access to filings. Court staff will see that when they process your filings, and then it'll help to ensure the appropriate document security. And again, remember, you separate public from non-public. If you do have multiple documents, or one's public, one's non-public, you should use separate filing codes for each document. And again, that'll help trigger the document security classifications and ensure that the non-public ones stay non-public. The other part of using precise filing codes, you select the filing code, and then you are also required to enter a filing description. And by the filing description supplements your filing code. An example we have here, we've got affidavit of plaintiff. The plaintiff's name is Jane Doe, and so the description is affidavit of Jane Doe. The filing description is then carried over into the public court record, and then if you'll see the comments in the Register of Actions, then that you can see it's affidavit of Jane Doe. And yes, I did actually find a real life Jane Doe case to get that screenshot with affidavit of Jane Doe. But think about it if you have a bunch of affidavits where it's affidavit of John Smith, of Jane Doe, of some other fake name that I haven't thought of yet. Well, it's a lot easier if you have those comments for the judge to locate which specific document that you have filed. And also remember, everything that you do file in the filing description, court records are public records, so whatever you put in the filing description field is likely to be a public record. Also with filing codes, they are also used for the EFS system to calculate appropriate filing fees. Filing fees in Minnesota are set by the legislature under Minnesota laws, and they are based on the type of document that you file. There's one fee for filing a petition or a complaint, another fee for a motion, a different for an affidavit. There's also a jury demand fee. Well, if you picked the wrong code than the EFS filing code, the EFS system may calculate the wrong filing fee for you. And then if you pick the wrong filing fee, well, court staff under the law are directed to reject filings for failure to pay the correct filing fee, and that is that is one of the 4 legal reasons they have to reject filings. Now, if your filing is rejected because you haven't paid the correct filing fee, then you have not, in fact, legally filed your document with the court. You can lose a filing deadline. And also, and again, the fee that you have will vary depending on the type of document that you file. By using the correct filing code, then you make sure that you'll have the correct filing fee assessed in EFS. Also, if you ever have a client with a fee waiver, you should make sure that you set up both a credit card account and a fee waiver account. By using a fee waiver account, instead of trying to charge your credit card for a $0 fee, it'll make clear to court staff that there's a basis for a fee waiver. It's not that you're refusing to pay the filing fees, it's just that you have had a legal basis for having filing fees waived. Another thing, always a good practice, number 7, allow time for processing. Now, the nice thing about EFS is, well, maybe it's not a nice thing, but I think we probably all wanted to do it, where you can file right up to the deadline. One of the rules were changed in 2015. As long as you have filed by 11:59 p.m. local Minnesota time, your document is filed as of that day. It used to be you had to get it into the courthouse by 4:30. You now have until 11:59 p.m. The thing is, EFS does a lot of the work, but the process is not fully automated. Each document is still reviewed by court staff after it comes through EFS. While EFS is available 24/7, court staff are not available 24/7. They're only paid to work a certain number of hours a day. They're human beings. They have to sleep. And so there does need to be some time for court staff to process your filing. There needs to be some time for judges to review your filings. I think with the transition to EFS, we have seen a lot. People realize that they can file right up to the deadline, and in some ways that's a good thing, but you still should allow some time for filing. If you e-file at 8:55 a.m. and your hearing is at 9 o'clock a.m., chances are the judge will not have your document at 9 o'clock. So yes, there are times if you have time-sensitive filings. If you do have a time-sensitive filing, then you should contact the local court administration. and alert them of the filing. If you're wondering if your document has been filed, you can go onto the court's website, look up the case records. If the document shows up under the case records, you can see it listed remotely, then it does mean it's available to the judge in electronic case records. Number 8 of the things that you need to know when you use the e-filing system: protect and perfect your appeal. I was trying to think of a catchier one here. How many of you knew that, actually most people in this building will know, the appellate courts use a separate e-filing system. It's called EMAX. Separate registration is required. It includes a quiz on the rules of civil appellate procedure. I can tell you from personal experience, it's a surprisingly difficult quiz. You really do need to know the rules of civil appellate procedure in some detail in order to pass the quiz, and only after passing the quiz will you be able to file an EMAX. Now, e-filing has been mandatory in Minnesota's appellate courts for all attorneys since July 1st of 2016. You'll remember from my cautionary tale at the start of this presentation, some things really can go wrong if you don't follow the appellate e-filing rules. We had the client who lost the right to appeal the termination of parental rights because there was an email instead of e-service. So make sure, since the appellate rules filings are strictly construed, that you are following those rules to the letter. In general, you can, if you're serving on appeal, you can use EMAX service, you can use mail, and you can use personal service. Now remember, as I said, e-filing has been mandatory for all attorneys in Minnesota since July 1st of 2016, so that's well over a year now. How many of you think that all attorneys are aware of this? I will tell you right now, not all of them are. 2017, June 13th, 2017, appeal is dismissed for lack of jurisdiction because attorney tried to file the appeal by mail on the last day. The appellate clerk staff sent the appeal back and said, you need to e-file. Well, by that point, it was too late. The attorney chose not to pursue that one. Next month, July 18th, 2017, appeal dismissed for lack of jurisdiction. Attorney attempted again to file by mail. Attorney said, then the attorney tried to fix this and said, I did not know that I had to e-file. I didn't realize it was mandatory. And even though the rules say e-filing is mandatory, it doesn't actually mean that I have to e-file. Again, the attorney at this point is now trying to fix this, but the Court of Appeals held you have not perfected your appeal within the timeline, and we don't have jurisdiction to hear your appeal. The attorney filed a petition for further review with the Minnesota Supreme Court that was denied September 19th of 2017. And then another one, this is kind of an interesting one, August 29th, 2017. Again, the attorney did not know that e-filing was mandatory at the appellate level, despite it having been more than a year since it went mandatory. Attorney tried to file by mail, and then a little bit later, once the attorney realized, oh, I have to e-file this, the attorney e-files it. The only reason that appeal went forward was because the Court of Appeals looked at the district court record and said, well, hold on, district court administrator, you entered judgment a couple of days too early, so actually judgment was entered properly about a week later, so yeah, the appeal is timely, but only because the district court administrator stamped the wrong document a little bit too early. So just, these are some examples of, again, going back to staying on top of the rules, making sure that you're following the rules, that these are all attorneys who, that the worst thing happened, they didn't stay on top of the rules, and 2 of them lost the appeal, or lost even the right to appeal. So number 9, going back to that theme of staying on top of things, staying current, that people should need to stay current on filing requirements. Remember, to practice effectively and to practice ethically, you need to stay on top of these requirements. As I said at the start, they have been amended several times in recent years. The rules have been amended, and you can find the most current versions online at mncourts.gov. I mean, I can tell you both the general rules of practice and the civil procedure committees are currently at work to recommend additional amendments to the rules. The process is ongoing, that the rules will continue to be amended to facilitate the operations of the court with electronic filing, and that does affect the obligations of attorneys. One of the changes has been formatting requirements. At one time it was you could file up to 4 megabytes per document at the district court level, and then The technology improved and it was up to 25 megabytes at the district court level. It also happens to be 25 megabytes at the appellate court level. They use separate systems, they're separate courts, separate technology, but for both of them, you're currently able to go up to 25 megabytes. There is a mandatory registered user filing guide that's posted on the website, much like the federal courts. Formatting requirements have been put into a mandatory guide. It's a little bit easier to update formatting requirements in a guide than in a rule. And under General Rule of Practice 1403G, you are required to follow the formatting requirements in the guide. If you have further questions about EFS, you can go to mncourts.gov/efile. And then for Emacs, emacs.courts.state.mn.us. Number 10, create pleadings electronically. This is an electronic court system. It may sound obvious, but pleadings should be created electronically. The formatting requirements in the registered user guide specifically say filers should not print documents on paper and scan them before filing them. We do see sometimes attorneys, it may just be this, what they're used to, or for whatever reason, are printing documents off on paper, signing by hand, and it's, again, that's the formatting requirements say you should not do that. Also, if you do scan documents, you cannot include optical character recognition data. Many scanners are set to include optical character recognition data. The thing is, with OCR, it can cause the EFS system to reject the documents for filing. And if you do, if your documents fail to process through the system due to failure to follow the formatting requirements, then you have lost your filing date. You have failed to file your document with the court. So again, you should be creating your pleadings electronically. And this, there are a few requirements, a few situations where you do really need to print on paper and scan, but under the formatting requirements, you do that only when it is not possible to convert an electronic document directly to PDF format. So a couple of additional reasons with scanned documents, they've got much larger file sizes. Remember, it's up to 25 megabytes per document. If you go beyond 25 megabytes, you have to split it into multiple documents. I will tell you the only way you will go over 25 megabytes is if you're scanning your document. I had to prepare a 1,400-page document not that long ago, and it was 4 megabytes just because I did it all electronically. If you do scan documents, it's harder to read. If you're like me, you write all of your pleadings and everything hoping that the finder of fact is just going to copy all of that very nice language that you have in your pleadings. It's very favorable to your position, and if you do it electronically, the judge can just very easily highlight that language, copy it into a draft order. Judges, there's nothing wrong with copying some effective language from a good advocate if the judge chooses to do so. But if you scan your document, it's much harder for judges to do that. A couple of common questions we've gotten. Is it necessary to sign by hand? There is a specific rule saying typographical signatures. If you type /s/ your name, under Minnesota law, that is an enforceable signature. And yes, that really is an enforceable signature. You don't have to sign by hand. That goes. There's a separate rule for judges, also in Rule 1404, but for attorneys, for external filers, anyone signing an affidavit, you can just sign typographically. In fact, we have a court rule that says, and a state statute that says you don't need to notarize. The statute says that you can sign under penalty of perjury. You are looking at up to 5 years in prison if you say something incorrect or say something that's false, just like you would if the document were notarized. So yes, I know it's maybe a source of some discomfort for filers. It is a change, but it really is not necessary to notarize your court filings in almost any situations. If you're working in an adoption case, then if you have a client who is waived giving up their parental rights, then that does have to be notarized. But other than that, you really do not need to notarize. Another change is there's a new court rule that was written in 2015 requiring consecutive page numbers. It makes it a lot easier for everyone to cite to the documents. With the EFS system, there's the document ID number. It's very helpful if you can say doc ID number 17 at page 35. That makes it much easier for everybody to locate the information that you're citing. We have a couple of minutes, and I actually have a bonus for you. I printed off, so you probably already knew that, but the bonus, number 11, is signing up for a service. We have continued to see some confusion with this, and so under the rules with EFS, you still have to add yourself as a service contact in each case. There's 2 steps. You first sign up for an EFS account, but you also have to add yourself as a service contact in each case. When you do sign up, remember also the rules prohibit you from signing up other parties for e-service. The rationale is making sure that when you're signing up for EFS, that is that party who has selected that email address at which to be served. Once you sign up for e-service, you are responsible for monitoring your email, and so that's why there's the prohibition on signing up other parties. Just another tip, you should only sign one person up as a service contact in each case. Sometimes we'll see it where you'll have 5 or 6 attorneys sign themselves up as service contacts from each law firm. The best practice is to add them as other service contacts in EFS. That way you'll get copies of all the documents. They will be served, but you won't see them listed on the Register of Actions every time they get served. A little bit different. Remember, EFS, Emacs are separate. In Emacs, by registering for an Emacs account, you are, under the appellate rules, agreeing to be served in future cases. And in Emacs, at the appellate level, you don't need to add yourself as a service contact. Remember, they are separate courts. They use separate systems. Their operational needs are different. They're provided by 2 different vendors even. So you don't need to add yourself as a service contact to cases. The clerk of appellate courts will add you as a participant to future cases, and other people will be able to serve you through Emacs. There's no need at the appellate level to add yourself as a service contact. Just remember, you do have to e-file at the appellate level. You just don't have to add yourself as a service contact. If you have questions, for technical questions, there is the EFS Support Center. I've got their phone numbers listed there. For the district courts, you can go to mncourts.gov/efile. You have the registered user filing guide with mandatory formatting requirements, and some detailed training documentation for how to use EFS if you or your staff have questions about the logistics of e-filing. For the appellate courts, they've got their own set of materials at emacs.courts.state.mn.us. And also there's the appendix provided at the CLE. I've got the text of all of the legal references that we have cited in this presentation. So happy to take any questions in person or through the webinar also. Not at the moment. If anyone has any questions on the webinar, please send them in now. Yes, please.
So proposed orders,
yes.
What is the current practice with respect to proposed orders? Some counties
yes.
vary in how they do that, so it's call ahead.
That's an excellent, with proposed orders, I was actually sitting in the same room in the committee that debated the proposed order, and they talked for about 2 hours on all of the different practices for proposed orders, and they eventually said, we're not going to put this in the rule. There are different practices, different judicial preferences, and so yes, I would certainly calling the county ahead of time to identify their practices, or calling chambers if different judges within the same county may have different preferences.
I think there was a pilot attempt, right, to have like Word docs submitted in certain counties.
That's in testing now. We're trying to, part of it is making sure that there's both the record of the proposed order, but also that it gets to the judge. So yes, at this point, there are some pilots in force right now, but I would contact the judge, or some judges, I think they actually have them on their judge bio pages on the Minnesota Courts website. They may have some additional guidance.
I've just got a request to repeat the questions.
Oh, I'm sorry. Thank you. I should have remembered. The question was for proposed orders, how to submit proposed orders, and the rules don't address specifically the process for submitting proposed orders. So my advice is to contact the county or to contact the judge's chambers. I think I should have remembered to repeat that. I've been in this room for several webinars. This is my first time actually presenting a webinar from this room, so I forgot that all the people watching had no idea what question I was answering. Yes, please. Yes, please. Thank you. I like questions.
So what happens if you have a case, you file and it's ongoing, and then you change firms? And so that case is coming with you.
Yes.
And let's say you're starting a new firm, for example. Is there a way to disentangle yourself? Basically, you should then, I guess, disentangle yourself from the prior firm, obviously, but
yes.
in terms of how you're registered through the EFS system, and then just start up a whole new
Yes.
Or whatever through EFS?
There are a couple of concerns. The first part you talk about, the question is if you, remember this time, thank you for the question was, let's say you change law firms and you, what do you need to do at that point with, if you have an ongoing case? There are two sides to it. The first part is in EFS, you have your virtual firm in EFS, and firm administrators within the firm can see the filing, they have access to filings within the firm. And so once you leave one firm and go to another, the former firm shouldn't be able to see your subsequent case filings necessarily. So what you should do is join your new firm in EFS with a new service contact, and you should also then add your new service contact in EFS. It's also, I know, an issue at the appellate courts. You need to contact them to advise them of your change in your service contact information. Or if you, you can also do it if you know ahead of time that you're going to be leaving, you know your new email address, you can also update your service contact information yourself. Otherwise, contact the clerks of appellate courts to update it.
Good, thank you.
A question from.
Yes.
What are the most common types of documents that are sealed rather than confidential?
The question, I don't know if I'll just read it so everyone can hear it.
Sure.
What are the most common types of documents that are sealed rather than confidential? Off the top of my head, I know we have a research department that can do all kinds of things with data analysis to tell you specifically what numbers of what types of documents are filed. But off the top of my head, General Rule 14 says that documents in parental notification bypass proceedings, that's a case where there's a bypassing parental notification where a minor would like to terminate a pregnancy, or also wills deposited for safekeeping. Those are not even to be e-filed, those are locked down. Also, with court staff, they are directed, if they see references to HIV in court documents, to seal those. If there is a case where a document might have images that, sometimes we'll see this occasionally in criminal cases or in family custody cases, if there are images of children where there's nudity involved, if there's a question about whether it's legally child pornography, that would be an example of something where it should be sealed. If there's, in general, nudity and depictions of nudity in court documents, or the concern there is, of course, just with child pornography, that there are some very significant legal issues with who has access to that. Those are examples of documents that would be sealed. In general, for the law clerks, if you have an order, if you say inaccessible to the public, then court staff can treat it as being inaccessible to the public. If the order is sealed, and if that's what the judge wants to do, it will be done. But what sealed means is that not only most court staff can't see it, won't be available. As you may know, government agencies, a lot of them have electronic access to court records. If it's sealed, they will not have access to it either. So just the distinction, those are some of the distinctions between confidential and sealed. One of the people in the audience, Katie Sutton, reminded me, Patrick, you can be a little bit long-winded sometimes. It's a little bit of a long-winded answer, but there are a lot of different things that can be sealed. Do we have any other questions from the webinar? And I do not see any other questions from the webinar. I do not see any other questions from the room. Thank you, everyone, for joining us today. The CLE number for today's session is 247731. And for those of you here in the Minnesota Judicial Center, there are some sign-in sheets outside. Thank you, everybody, for joining the CLE today.